Well, let's start with that top story. There has been a tense exchange of correspondence between the Public Protector and the President. Last week, the President sent her a letter asking her for reasons why he shouldn't suspend her. The Public Protector has had many court rulings overturning her findings, and last week Parliament said it would continue its impeachment process against her. The President's intention to suspend her is against that backdrop. But now Mkhwebane has fired back. In a lawyer's letter, she says the President is conflicted and he has no legal basis for his request. Well, let's get some legal insight now, and I'm joined by Associate Professor of Public Law at the University of Cape Town, Cathy Powell. Hi, Cathy. Thank you so much for joining us. So, the President wrote a letter and he cited Section 194(3)(a) of the Constitution, explaining that he has a right to do this, and he asked her for reasons why he shouldn't suspend her. The Public Protector says, well, he's got no authority to do this because she has many reasons, but she says he has no legal right to do this. So, is the law clear on this issue or not?
Crystal clear, I'm afraid. There is no way the Public Protector can claim that he doesn't have a right to suspend her. Let's just have a look at 194(3). It's very simple. It says the President may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person.
Yeah.
It's in the Constitution. And what's happened is that a committee of the National Assembly has started proceedings for the removal of the Public Protector. It has informed the President of that fact, and he now, under Section 194(3)(a), has the power to suspend her. So he's given her the chance to persuade him not to, but he has the power. For her to come back and simply say, no, you can't do this, it's magical thinking.
She seems to be also saying, though, that perhaps she's suggesting that he is legally disqualified because he is potentially conflicted. I mean, she says in the letter that the preliminary objection based on your actual potential or reasonably perceived conflict of interest, and goes on to say that the reason is that the President is personally heavily conflicted in this matter due to various investigations, mentioning Bosasa, CR17 coming up again, all of those issues. So does she have a point when it comes to that, though?
Yes. What she's relying on there is the duty of a decision maker in any administrative decision not to be judged in his or her own cause and not to be biased. Now, when this is applied in the context of a decision made by Parliament, it's a parliamentary process in which the President is playing a role. This is slightly more difficult, and earlier case law has pointed this out, because the Public Protector is obviously going to be acting against members of Parliament and members of the executive. So if they were not allowed to hold proceedings against her for that reason, she would be untouchable no matter how bad her decisions were and how bad her misconduct is. So the rule against bias has to be applied through a slightly different process whereby you ensure that there are safeguards and safe proceedings to govern the case. Now, what you've got here, and it's the rules that have been set up by the eNCA, is that a truly independent panel, so 3 people who are not part of Parliament, who are not part of the executive, have looked at the evidence, have examined the facts, have examined the various cases in which courts were scathing of what the Public Protector had done and said, and have said on the basis of all of this, we find a prima facie case of not just incompetence but misconduct, and we recommend an investigation for removal. Now, at that point, the President is not simply making a decision based on the effect on him of the Public Protector's reports. He's making a decision based on what that independent panel has held. Now, yes, the Public Protector has held against the President, although those cases did him no harm because they were overturned by the courts. And I think the main point is that the actual substance on which he's taking the decision to suspend is a full report based on a number of cases, some of which didn't involve him, and all of which were led to be serious enough, were held to be serious enough, that the public protector should be considered for removal. So I think, although the idea of bias is possibly her strongest argument, it's not going to win in this case.
And at the same time, she's taking on the Constitutional Court. She's made that Recision application. Gosh, where have we heard that before? She says the Constitutional
Indeed.
Court made 6 mistakes or ambiguous decisions in ruling against her. So the only way to get any kind of leeway after a final decision by the Constitutional Court is this Recision application, which normally means you've brought something absolutely new. Yeah. So, but if the Constitutional Court, let's say they did agree with her, would she not have a point that the President is acting prematurely in a way?
No, it's definitely not premature, because as Section 194 says, the moment a committee has started proceedings, the President may suspend. He has that power, he has that discretion. So it's definitely not premature. And remember, what the public protector is seeking rescission on is a decision of the Constitutional Court that the process that Parliament set up to remove or to determine whether to remove the public protector, whether that process is fair and constitutional. And the court has said yes. And in applying for a rescission of that judgment, what the public protector is in fact doing is she's trying to appeal. Now, the rules for rescission have been clearly set out because, as you yourself point out, both Mkhwebane herself and Zuma have tried it recently. And through that process, the rules were clarified. And she has no basis to claim a rescission. In fact, I strongly suspect, and I think it would be appropriate, if there were a costs order against her, personal costs order for this rescission application, because she's simply wasting the court's time and she's delaying she's trying to delay the process, although it won't work, that Parliament has to go through.
But it's clear from this letter from her lawyers, she says, please indicate your urgent response by 4 o'clock on the 23rd of March, this is to the President, failing which urgent court proceedings will be instituted. And she says, whether you answer or not, I'm going to court. So she's launching another court process. So I want to ask you, what happens now? Because if something goes through the court process, does Parliament have to wait? Or is Parliament able to say, well, we've got this Constitutional Court ruling, we're going ahead? I mean, how does it work now? Could we be in for a protracted legal battle on the basis of the letter that the Public Protector has sent?
No, I don't think her letter is strong enough. And we have the Constitutional Court's own authority, because she has previously tried to get the proceedings of Parliament held up while the Constitutional Court considered the validity of the parliamentary rules, and she was unsuccessful. So Parliament was allowed to proceed with its Section 194 process while the court was considering whether that process was constitutional. So what she's in effect doing now is she's trying to argue that the next step in this process is unconstitutional, which is that the President can decide to suspend. And now that's a tough argument to make if the President's power comes from the Constitution itself. And I get your point. She's going to try to argue bias. She's going to try to argue the President can't decide a matter if he has any personal investment in the matter. But remember, we're talking about Parliament here, and we're talking about the actual body that's meant to oversee the public protector, and we're talking about a group of people that the public protector ends up having to investigate all the time. There's no way they can't be in some way affected by her rulings and her reports, but that doesn't mean they mustn't carry on exercising their powers and fulfilling their duties under the Constitution.
Thank you so much for all that clarity. Really interesting insights there. Cathy Powell, Associate Professor in Public Law at the University of Cape Town.